trial, the process. Let's use a criminal case, for example, one that most people understand the most, and the ones that we see on TV, and the ones that are probably the most entertaining and the most fun to watch. Now, in a criminal case, a judge will bring in a panel of jurors. And the first step, at least out here in the state of Nevada, is the judge will introduce the parties and the lawyers will each get up. The prosecutor will go first. Sometimes they'll do what's called a little mini opening, kind of talk a little bit about what their case is about, read some of the charges, and then they'll tell the jurors some potential witnesses in the case to see if those potential jurors know who those witnesses are, in case there's a relationship with one of them, they know them, or there's some type of potential bias. Then they will say, defense, you get up. And then I will get up and I'll give a little pitch about my case. Not going to try to make my case look too good. I want to try to weed out the bad. So I'm going to tell the bad stuff about my case. Then I'm going to read who my potential jurors are. I'm going to introduce myself. I'm going to introduce my client. I'm going to humanize my client, and I'm going to let them know this is a real human being here. Then the judge will start to do some preliminary jury instructions, read some of the rules and things to the jury about how they're not to be talking amongst each other when they go outside. If they see the lawyer when they go out in the hall, don't be offended if the lawyer doesn't talk to them. We're not allowed to associate or communicate with the potential jurors or the jurors in any way. Then we will start jury selection, also known as voir dire. The main purpose of jury selection is to try to find bias. Are there jurors in this panel that are going to be biased either towards the defense or towards the state? And also, you're trying to do some tribe building. After jury selection, when each side has completed its speaking to the panel, we're going to do strikes. We're going to strike those jurors for cause. Cause challenges mean that the juror just can't be fair. They've said something that excuses them for cause, meaning they have a bias, a clear bias that they've said on the record. And those ones get out automatically. Then each side also gets what are called peremptory challenges. Now, with peremptory challenges, we're allowed to excuse a juror for any reason we want to. If we just don't like them, we don't like the way they looked at us, we don't like what they do for a living, the only thing you can't excuse them for is gender or race. Sometimes you'll strike a bunch of jurors and they look and they say, oh my God, you struck all these women on the juror or all these men on the jury panel. It's up to whoever side creates this challenge. They have to give a gender neutral reason as to why they struck the juror, or on a certain race. If they struck too many of a certain kind of race, one side makes a challenge to how those jurors were struck. The lawyer has to get up and give a race neutral reason as to why those jurors were struck. In the end, generally what you have is 12 members on the jury that are going to sit there in either 2 or 4 alternates. And then the process will start.